Hey, what's up everyone? This is Ben from Law. In this video, I'm going to talk about limitation of liability clauses. What is a limitation of liability clause? It is essentially a clause that says that if anything bad happens because of the goods or services that I have provided, anything bad happens, don't blame me, I'm not liable, do not sue me. Where can you find such clauses? Well, you can find them in terms and conditions. You can find them for contracts for the sale of goods, for the manufacture of goods, supply of services. I know many of you do not read terms and conditions, and many of you also do not read contracts, but it is a very common clause. Why do people tend to put such clauses in contracts? It's very simple, to cover their ass so that they cannot be sued if the goods or services they provide are defective. Now, let me discuss the common clauses in a limitation of liability clause. The first common thing would be that the seller or the service provider does not give any warranty as to the goods supplied by it or the services provided by it. What is a warranty? A warranty is, in the legal sense, is not the kind of warranty you get when you buy electronic equipment where they give you a warranty for a year. In the legal context, a warranty is a statement of fact which is supposed to be true. So yeah, basically they do not make any warranties as to the fitness of purpose, or whether it is the suitability or the quality of the goods or services supplied. Another second typical clause you would find in the limitation of liability clause is that the service provider or the seller is not required to indemnify the customer. What is indemnify? Indemnify essentially means to compensate. So if you use the product or service and you suffer loss or damage, they are not required to compensate you. A third common clause that you can find would be that the service provider or the seller shall not be liable to the customer or any other third party by reason of any implied warranty, condition, terms, or duty at common law. What does this mean? It means that if you use the product or the service and somebody else uses it, for example, you make use of some kind of service and someone else uses the report or whatever, and something goes wrong, they rely on the report or they rely on the product, something goes wrong, you cannot sue the service provider or the seller of the goods. A fourth issue that is typically found in such clauses would be that the service provider or the seller is not liable under contract or tort or otherwise for any economic loss of any kind, including without limitation, loss of use, loss of profits, loss of anticipated profit. What does this mean? For example, if you enter into a contract for someone to manufacture machinery, okay? And then you have a limitation of liability clause in this contract. After the machinery is delivered, you're using the machinery for a period of time, and then it breaks down for 2 weeks. And because it breaks down for 2 weeks, you lose $100,000 in revenue. What this clause essentially means is that the loss of profits, you cannot claim against them. They're not responsible. The fourth common matter that is dealt with in such clauses would be the seller or the service provider is not responsible or liable for any special, consequential, incidental, punitive, exemplary, indirect losses, whether in contract or tort arising from the supply of the goods. Tort is a civil wrong, okay? An example of a tort would be negligence. So in other words, even if they are negligent and something happens because they are they were negligent in the provision of the services or the products, they are not liable. So the final layer that people like to insert a final layer to protect themselves, is that in the event a court finds that they are liable, their total liability will be capped at the invoice price or the purchase price paid. So for example, if you paid $50,000 for the machine, or you paid $50,000 for the services, and if they are found to be liable by the court, the maximum that they will pay you is $50,000. So even if you lose $200,000 because of the defective product, you're only entitled to claim $50,000. So always be careful when you come across limitation of liability clauses. If possible, negotiate for it to be deleted, because it's not, from a customer's point of view, it's not in their interest to have such a clause, because you're paying for a service or a product. You want the service provider or the seller of the goods to be responsible for any defects. Okay, so that's all I have to say about limitation of liability clauses. If you like this video, please click like and subscribe. Thanks for watching.